Good morning, everyone, and welcome. Thank you for joining us today at our live virtual event titled Working with Landlords and Tenants. My name is Darcy McLeod. I'm your host this morning. I'm a realtor just like you. I'm with eXp Realty here in Vancouver. Before we get started, I'd like to introduce our title sponsor for today's online webinar, By Design Construction. They're a second-generation real estate development and investment company. By Design has proven itself as one of the top home builders in Vancouver. They focus on working with clients and partners to maximize returns while balancing risk tolerance and time to value. Their aim is always to create the right match every time. Thank you, By Design, for sponsoring this event. For all of you participating this morning, please hold your questions until the end of the speaker presentations. We'll have a panel Q&A at the end of the session to address all of the speakers at the same time. And we'll try to get as many of you as we can and answer your questions during that time. Once the Q&A period is open, you can type your questions in the Q&A section found in the panel at the bottom of your screen. Now let me introduce our first speaker, Kimberly Coates. Kimberly is the Director of Member Engagement with Landlord BC, has been with the organization since 2014. Her role focuses on membership development and ensuring that Landlord BC members are taking full advantage of the value they receive as members of the association. Additionally, Kimberly drives Landlord BC's marketing initiatives, including the corporate supplier program and member-exclusive group programs. As one of the leaders of Landlord BC's team, Kimberly works diligently to ensure that Landlord BC's message and core values are well communicated to the membership body and the broader industry. Please welcome Kimberly Coates.
Thank you very much. As mentioned, my name is Kimberly Coates, Director of Member Engagement with Landlord BC, and I just wanted to do a quick chat and introduction about Landlord BC, who we are and what we do. So Landlord BC, we're the industry association that represents owners and managers of rental housing. So whether you are a licensed third-party rental manager, or you're a private landlord who might have a secondary suite or an investment property, we have resources and support to help you manage your business, mitigate your risk, and really set yourself up for successful tenancies. So whether you're looking for things like our proprietary tenancy forms, that's a great value added for our membership. So we have the tenancy application, the residential tenancy agreement, and the condition inspection report. Those are exclusive to our members. Excellent, robust paperwork that covers a lot of the things that aren't covered in the standard agreement that you can get off the government website. So that's one of the great values added for membership. And as mentioned in my introduction, we also have group programs that our members can take advantage of. So we can help save you some costs on things like property insurance. We have a credit checking partnership that helps you save some money in the process of screening your tenants and those types of things. The information we're going to be providing today, that's another huge part of what Landlord BC is all about. So the legislation that governs our industry, the Residential Tenancy Act, it lays out a landlord's rights and responsibilities, as well as a tenant's rights and responsibilities. And one thing that we find as an association is that a lot of times where landlords can run into trouble is when they don't fully understand certain aspects of the legislation. There's some really, really important points in there that if they're not followed, can get a landlord into a lot of trouble. It can get tenants into a lot of trouble as well if you're not following this legislation. So we really focus on educating the full rental sector, educating the broader industry on what it actually means to be a landlord and what it actually means to operate a rental housing business. Advocacy is another huge part of what we do, and that ties into our education piece in that we want to be sure that landlords understand what it means to be a landlord so that we can advocate on your behalf and ensure that we're working with the government to create a very balanced rental industry. So we always refer to it as kind of the rental housing ecosystem. So we need to have landlords who are able to provide secure, safe rental housing to tenants. And then we also need to have tenants who are able to have respectful landlords and have that nice business relationship where they're paying their rent, the landlords are providing that housing. So it's really important to the viability of our sector that that's kept well balanced, and Landlord BC plays an intricate role in that, ensuring that we're educating society on what it means to be a landlord, educating people on how the rental housing industry works, what the rental culture is like in BC, and then also working with government to ensure that that balance remains intact, that landlords are able to operate their businesses, while tenants are able to be provided with that important housing. So my contact info is up on the screen there for you. I really encourage you to take a look at membership with our association. We are a not-for-profit membership-driven association. So we do require rely on people joining with us in order to operate and do what we do. Feel free to reach out to me via email or give me a phone call if you'd like more information about membership. And we also have an excellent non-member e-newsletter that you can sign up for at the very bottom of our website. And we work to keep the broader sector up to speed on things that are going on in the industry, especially during the COVID-19 pandemic. We worked really hard to be sure that people knew, how they needed to adapt their businesses to address this strange time that we're all living in, whether it's, encouraging more communication with their tenants, working with their tenants regarding rental issues, having to close certain common spaces to encourage social distancing. We have a lot of really good information and an excellent toolkit available for members as well as non-members to take advantage of there. So again, if you have any other questions about Landlord BC, I'm happy to answer them at the end of this. And you're also more than welcome to reach out to me at any time if you think of anything over, the next few weeks, if you'd like some more information. And that's all I have for this part. So Darcy, I'll pass it back to you, and thanks very much.
Thanks so much, Kimberly. Great information. You know what? It's really nice to see that there's about 80 people on this webinar this morning participating. Thank you for taking the time, and it's great that you are all engaged and interested enough to take the time out of your day to join us. Again, thank you, Kimberly. Next up, we have Hunter Boucher. Hunter is the Director of Operations at Landlord BC. He has over 12 years experience working within the rental housing industry and a background and expertise in legislative issues and industry best practices. Hunter has taken on many roles with Landlord BC, including the development of the robust webinar series, presenting at various workshops across the province, and managing Landlord BC's legislative helpline. Welcome, Hunter, and thank you for being here.
Thank you so much for that introduction. And welcome to everyone who's joined us this morning. I don't know where everyone else is, but it is gray and cold here. So, typical summer weather. It's only rained twice this summer, I think, once for 20 days, another for another 15 days. So, typical summer. So today we're going to be talking about buying and selling tenanted properties. Now, obviously, in any situation in a tenancy, it's there's difficulties that can arise. It's a complex process being in a tenancy, whether you're the landlord or a tenant, or even more so when you're somewhat of an outside party, a realtor, kind of being that additional party in a tenancy during the process of purchasing and selling a tenanted property can be quite difficult. So there's quite a few things that need to be considered, both that you as a realtor or a landlord need to consider, and things that the tenant need to consider. So we're going to focus on this from a point of view of a landlord, which is what we at Landlord BC generally do. We're here to assist landlords. So these are things that landlords need to consider. So you as a realtor, when you're dealing with a client, you need to make sure that your client is aware of these things. They should be asking you some of the questions that we're going to go through here. But if they don't bring up these questions, then it's a good idea to have these conversations. So we can go ahead and move on to the next slide. So what are some of those things that you need to consider? Well, you need to consider things like what notices need to be given. What if the tenant is not cooperative? What do the new owners want? Do they want it to be a vacant unit? Do they want to use it as a revenue property? So there's quite a bit that a landlord needs to consider when they're selling their property and when it is tenanted. So we really break it down to those three big questions. What kind of notices do you give your tenants when selling the rental unit? What if your tenant is not cooperative? And what do you do if the new owner wants vacant possession? So we can go on to the next slide. So what kind of notices does the landlord need to serve when selling a rental unit? So you have a tenant who is living in the rental unit, you put it up for sale. What notice needs to be given? Well, the answer to that is none, or possibly quite a few notices. It really depends on the situation. Listing the property itself does not require any notice to be given. So when the property gets listed, the tenant doesn't need to legally receive any type of notice. Now, this is where we kind of verge off of what the legislation says and look at what are some best practices. So again, when listing a property for sale, you don't need to give written notice to the tenant, but this is a good time to have a conversation with the tenant about what this process is going to look like. This is a great time, in fact, to have the landlord and the realtor be part of, and the tenant, all be part of a group conversation. And obviously, given the context of where we are today during a pandemic, this might be done online. There's many tools to do that. We're using one today, Zoom. So have that conversation. Start with that. It's not about giving notice. It's about simply letting them know. But listing the property itself does not require any legal notice. So then we look at what notices might come into play. What types of notices? Well, if you intend to show the unit to potential purchasers, which likely you're going to do when selling a property, you need to give a notice of entry. This notice must be in writing, and it must be received at least 24 hours before you intend on entering the tenant's unit. So this goes for whether it's the landlord that's entering or the realtor that's entering or another realtor with potential purchasers. There's a lot of different ways that can go down, but you do need to actually serve a written notice that you intend on entering the unit, and it must be received at least 24 hours before entering. The other thing to be aware of is that the method of service for documents is important. So Kimberly mentioned at the beginning that there's the Residential Tenancy Act and it governs our industry, and it does very, very closely govern our industry. There's a lot in this piece of legislation that really gets down to the minutiae, including how you serve a piece of paper. So when it comes to serving documents and serving a notice of entry particularly, this rule will apply to any notice, but it really comes into importance when we talk about notice of entry. You have to take into consideration how long it's going to take to get to the tenant. So for example, if you post something on a tenant's door, it's considered received 3 days later. So if you want to go in tomorrow, you can't just post it on the door. You'd have to give it to them personally. Same with putting it in their mailbox. It's considered received 5 days later if you were to send it by mail or registered mail. When we talk about mail or registered mail, it must be through Canada Post. Now, a lot of landlords and property managers and realtors will use email or text message to let tenants know that you're entering the property. And in general, this is okay if you get a response back from the tenant saying, yes, you can go in. So if you're emailing or texting the tenant saying, may I go into the property at this specific time tomorrow, and they get back to you and say yes, then great, you can enter the property. But if you're simply serving them notice and they're not responding back with an affirmative, then email and text message are not allowed. They're not legal methods of service. Email will likely become a legal method of service fairly shortly. We're hoping early fall that will be introduced to the Residential Tenancy Act. I've been working with with this organization for 12 years. And when I started, this was one of the big focuses, was getting email as an approved method of service. And we're hopefully actually at that point now. But considering the method of service is really important, making sure that you know how the tenant's going to receive it, when they're going to receive it, and when your notice will be effective. So we can move on to the next slide. But what about ending the tenancy? Don't you end the tenancy when you're selling a property? Well, the answer to that is generally no. Putting a property on the market, or even selling the property, even the actual act of selling it itself is not reason enough to end a tenancy. It is not enough to end the tenancy. And we are going to cover the process of ending a tenancy, but it's important to note that the first step when listing a property, even selling a property, isn't necessarily ending the tenancy. Like I said, we will get to that in a few slides. We can go to the next one. So what happens if your tenant is not cooperative? You've communicated with them that you're going to be selling the property. You've informed them of the process. You've given them notice. You've given them specifically notice of entry that you're going to be entering and showing the unit to potential purchasers. Well, what happens if they're not cooperative? What if they start trying to seriously hinder your ability to sell the property? Do you have recourse? And the answer is yes. You certainly do. We first have to make sure that you've done everything that you need to do up to then properly. So that includes serving proper notice of entry when you're entering the unit. If you've done that and the tenant blocks access to the rental unit, you are able to address that issue by starting with a caution notice. And a caution notice is a notice that allows you as a landlord or as a realtor, or as the agent for the landlord, to address an issue with the tenant. It's a very serious step, giving a caution notice. The reason we say it's a very serious step is because the next step after giving a caution notice is to serve a notice to end tenancy. So we generally recommend that if a tenant is refusing entry to the unit after you've given notice, try to communicate with them again, try to get them on board with the process. But if they're not going to get on board, if they simply do not want to cooperate with this process, then the next step is giving that caution notice. Now, caution notice needs to contain several things. It needs to say what the issue is, how to resolve the issue, when to resolve the issue by, and what the consequence is should the issue not be resolved. So in a situation like this, when we look at what the issue is, well, the issue is you, tenant, have blocked entry to the tenant to the unit, which has hindered my ability to sell the unit, which is my lawful right. And under the Residential Tenancy Act, a tenant cannot hinder or jeopardize a landlord's lawful right. So again, what the issue is you've blocked access, jeopardizing my lawful right. How to resolve it? Comply with the notice of entry that we will give you for the next time we want to enter. And when to resolve it by? Now, normally when giving a caution notice, we have to give a reasonable amount of time before this takes effect, before we want this thing resolved. But for something like this, we can expect that will be immediately. That would be a reasonable amount of time because they don't need to really do anything. They simply need to comply with the notice. They simply need to let you into the unit when you give a notice of entry. And then the last part here is the consequence, which we've already actually mentioned. The consequence to not serving or to not complying with a notice of entry from a tenant standpoint is that they'll receive a notice to end tenancy. And specifically, they will receive a 1-month notice to end tenancy for cause. So as we can see, the caution notice is something that escalates very quickly and should only be given when you are ready to move on to the next step. At Landlord BC, we very much do not advocate for ending tenancies. We know that sometimes that is what is going to need to happen, that ending a tenancy is sometimes what has to happen. And there's a variety of reasons as to why that might come up, but it shouldn't be the first step. So again, we start with a caution notice and we move on to the 1 month notice to end tenancy should that need to occur if the tenant doesn't then comply. Now, not letting you into the rental unit is just one way a tenant may not cooperate. They might perhaps leave the unit in such a state that it's not showable. So they have their clothes strewn across the unit, got pizza boxes everywhere. They have dishes in the sink and on the counter, or maybe just throughout the rental unit in general. They haven't taken the garbage out for the last 2 weeks. There's all sorts of things that can happen, and maybe it's just the way that they live normally. Most tenants don't. And to be very clear, most tenants and most tenancies are very, very positive. But in those circumstances where it's not, and where a tenant is perhaps leaving the unit in a state that doesn't allow it to be shown, that is also jeopardizing the landlord's lawful right. Additionally, leaving a rental unit in a state like this can potentially damage the unit. It can potentially attract rodents, vermin, or pests. So that's something that can be addressed as well through the process of a caution notice, and then eventually following it up with a notice to end tenancy. So we can move on to the next slide. So what happens if your tenant lies to a purchaser? And what do we mean by that? So certainly, if you have a tenant who's just not being cooperative, that's a problem. But what if when showing the unit, they start telling lies to the potential purchaser? They don't want the property to be sold because they think it might end their tenancy, and it might, and we'll get to that in a moment as mentioned. But what do we do if the tenant starts lying to a potential purchaser, saying things like, oh, just so you're aware, there's a serious rat issue in the basement, and perhaps there really isn't a serious rat issue in the basement. Well, this really is the same thing as jeopardizing the landlord's lawful right. And in fact, it's actually written in the Residential Tenancy Act as a reason to end a tenancy. Should the tenant lie to potential purchasers, that is a reason to end a tenancy. So again, it would be a caution notice, and then moving on to a notice to end tenancy. Now, this is not always easy to prove. You really need to make sure that you have this well documented, which leads us to documentation. Throughout this entire process, documentation is your friend. You need to document everything. Even if everything is going really well, you need to document everything, because very quickly things can turn. And if they do turn, you need to have that paper trail showing what has occurred throughout this process. And especially when there is an issue, like what we're talking about, when a tenant has potentially lied to a potential purchaser. So if that happens and you have a tenant who has lied to a potential purchaser, then document that lie. Have the potential purchaser write out a statement saying, this is what the tenant said to me. Now that can be difficult because they just want to buy a property. They probably don't want to get involved in your drama, and fair enough. So it might take a little convincing on that part. But certainly doing what you can, as much as you can, to document this issue. Now, this is how we deal with tenants who are not going to cooperate with this process of selling a property. And I'm sure as realtors, many of you have come across this. As landlords, many of you have come across this. This is not an uncommon thing. It's not an incredibly common thing. It doesn't happen all of the time, certainly, but it does certainly come up. So we've talked about how to deal with it, but really more importantly is how to avoid this. And really what we recommend doing is doing as much as you can up front to get your tenant on board with this process. So explaining to them the process that you're going to go through. So we talked about earlier about having a conversation with the tenant to say, okay, we're going to be showing the unit, and this is the schedule that we're going to come up, and try to work with the tenant as to what that schedule looks like. Work with the tenant as to what a reasonable level of cleanliness is, if that's something that's needed, if they're not already, fairly clean tenants in terms of their property. It also might mean doing things like, a small gesture, a gift card to a restaurant. In fact, that's a great way of making sure the tenant might not be in the unit when you're showing the unit, showing it to potential purchasers, is providing them with a gift card to a cafe down the road, for example. A gift goes a long way, and realtors certainly know that. Providing a small token of your appreciation to this is a great way. In times before COVID-19, what we found is a really successful strategy was getting together and having a meeting, saying, "Okay, we'll order a pizza, and we'll have a conversation about what this is, and make sure everyone's on the same page, and go from there." And that can be a really great way of breaking the ice, getting them comfortable, and getting their buy-in on this process. So let's move on to the next slide. So what do you do if the new owners want vacant possession? So we've talked about giving notice of entry because the tenant has done something wrong, or they're not cooperating. But you may also end the tenancy after the property is sold if the new owner wants the unit to be vacant. There are some caveats to this. There's a few things that they need to happen, or need to be in place before you actually serve this notice to tenancy. So you need to consider a few things. The first thing is that notice to tenancy, specifically the 2-month notice to tenancy, which is the notice that would be used in this situation, the effective date of that cannot be prior to the end of a fixed term. Additionally, notice can only be given if the new owners intend on living in the rental unit. When we say the new owners, it can be the new owner, their spouse, or their close family member. And they would have to live in the unit for at least 6 months. Further to that, the definition of close family member, because the Residential Tenancy Act certainly defines this for us. They don't leave us guessing as to what a close family member is. A close family member is a parent or child of the landlord or the landlord's spouse. And in the context of what we're talking about, the new owner would be the landlord. They are becoming the landlord. Even if the tenancy ends prior to them moving in, they will become the landlord for the context of this form. So again, this notice can be served in situations where the effective date will not be earlier than the end of the fixed term, if there is a fixed term, and if it is that, in fact, that the owner, their spouse, or their close family member will be living in the unit for at least 6 months. It's also really important to note that there is a penalty if this is served in bad faith. So when serving a notice to end tenancy, specifically the 2-month notice to end tenancy, the reasons to use this notice are very, very narrowly defined. Again, as we said, they don't leave anything to guesswork in this situation. If this notice is served, and this is something that the seller and the purchaser both need to be very aware of, if this notice is served and then the owner or their close family member does not move in to the rental unit and say rents it out to someone else, or just doesn't live in it, or does something else with that rental unit, but does not do what they said they were going to do on that notice to end tenancy, the penalty is 12 months rent. So clearly that's not insignificant. In Vancouver, 12 months rent, average rent, you're looking at a minimum of $12,000. There's very few rental units that are going to be less than $1,000 a month. But you're more likely looking at about $24,000, so not an insignificant amount at all. That is really a big consideration that needs to be made. You can't serve this notice in bad faith. And obviously, we wouldn't recommend serving it in bad faith even if there wasn't this significant penalty. Operating in an ethical manner is a key part of Landlord BC. So we can move on to the next slide. So what happens if you've served notice, you've served the 2-month notice, then tenancy? What happens? Now what? Well, if you do meet all the requirements to be able to provide vacant possession to a new purchaser, to a new owner, then again, you would serve the 2-month notice for landlord's use. And there is an option specifically as mentioned on that form that fits that situation. The tenant gets 1 month compensation. Generally, that means the tenant just doesn't pay the last month's rent. So when talking to a landlord, when dealing with landlords need to be aware that there is this additional cost that comes with this. And this can sometimes be part of the purchase agreement as to who's going to pay for that. But nonetheless, this is an important part of the process that needs to be made very clear. On a month-to-month tenancy, so specifically if we're looking at a month-to-month tenancy, not a fixed term tenancy, the tenant can turn around and give 10 days notice and leave early. So if you served a 2-month notice today, for example, tomorrow, the tenant can come back and say, okay, well, here's my 10 days notice and I'm leaving early, which means they aren't going to pay next month's rent, but they still get that 1 month compensation. So instead of getting a month's free rent, as they normally would if they were living in the unit, they actually get paid 1 month's rent because they're not living in the unit. The value is that month's rent. This notice can also be disputed. And in this process, they have 15 days to dispute this notice. So we talk about disputing this notice. We mean the dispute resolution process provided by the residential tenancy branch. And it's called dispute resolution, as mentioned. And what this process is essentially the tenant makes an application. They'll get scheduled a hearing. And regardless of whether there's merit to their case or not, they will be scheduled a hearing. When someone makes an application, it generally is just accepted. And the decision is made at the hearing itself. If a tenant does apply to dispute this notice, they need to serve the landlord with notice of this hearing. And the landlord and the tenant both have an opportunity to submit evidence. In a situation like this, the landlord should submit as much as is possible to prove that they are serving this notice in good faith, that the new owner does in fact intend to move into the unit. So it might be that you're required to ask that new owner to sign an affidavit or sign a notarized letter saying that they do in fact intend, or their close family member does intend to move into the rental unit and reside there for at least 6 months. And if that's the case, the hearing itself should be fairly quick, fairly easy. While we can never guarantee what the outcome of a hearing would be, in general, we find that these types of hearings, in situations where things were done correctly, well documented, aren't really a problem. They're more of a formality. At the end of that hearing, additionally, you'll get an order of possession, which kind of can cut down on some of the work that you need to do later on to remove the tenant should they not end up leaving. We can move to the next slide. So when we look at this, so we can actually move to the next slide. Perfect. So what do I need to consider when purchasing a property? So this is the other side. We've talked about what happens when someone is selling a tenant property. And obviously, as we can see, it's a bit of a complicated process. There's a lot of different factors that need to be considered. From the other side, when purchasing a tenant property, in many ways, it's someone going in blind. You're going into a situation often without knowing the whole story. And I mean, purchasing a property in general is in many ways sometimes kind of mysterious. You don't always know everything about the property. You're probably going to end up having well, you should certainly end up having an inspection done. So you're going to get a lot of information about the state of the property itself, but the tenancy is something that's a lot harder to document as to the state of the tenancy. And certainly paperwork is an important part, and we'll certainly make sure that we cover that topic. So it's really important to ensure that as a realtor going into this, as a landlord going into this, that the right questions are asked to ensure that the purchaser has all of the information as they can, as much as they possibly can. And in some cases, there might be information that means they don't want to purchase the property. Things like what the rent is, for example. If the rent is quite low and they want to purchase it as a revenue property, that could be a problem. We'll get into why that's a problem in a few moments. We can move on to the next slide. So that is the first question that needs to be asked. When talking to a purchaser or as a purchaser, the question needs to be asked, are you purchasing this as a revenue property or a personal home? Are you going to live in the home yourself, or are you going to rent it out? And you need, generally, in most cases, the purchaser is going to know what they have. They already have an idea in mind. They're purchasing a property to move into. Sometimes they might not be entirely clear. And in those situations, it can obviously be quite a problem. But make sure that you have this clear. So that really needs to be the first step. And as realtors, certainly you're aware of asking those types of questions. So if you intend to purchase the home as a revenue property, you need to know that you must keep the existing tenants. So when you purchase a revenue property, as we mentioned before, for the seller, there's no notice that is given to tenancy, except for those very narrowly defined situations. So if there's actually a problem in the tenancy, or if the new owner is going to move in, which is the next thing. If you're going to purchase the property because you intend to move in the rental unit, you need to ensure that the seller can actually provide vacant possession, because there are situations where they may not be able to provide vacant possession, or at least vacant possession in a timely manner, in a way that works for you. So that needs to be really aware, because those expectations on everyone's side need to be made clear so that there isn't a disappointment down the road. An example of a situation where a tenant or a landlord would not be able to give vacant possession to a new purchaser is in situations where you have a fixed term tenancy that isn't coming to an end anytime soon. So perhaps the tenant just moved in and they have a 1-year fixed term. Well, that 2-month notice to end tenancy can't come into effect prior to that the end of the fixed term. So that's a really important thing to be aware of, that if you're purchasing this property, you might be able to move in, but it might be a year from now, or 2 years if it's a 2-year fixed term. Not as common, certainly, but it does happen. So when we look at that and being aware of those types of things, that's what a potential purchaser needs to be aware of. Those are the decisions they need to make. before really even looking at a property. And then once they do look at the property, they need to make sure that it's actually going to meet their needs when it comes to getting possession of the rental unit. So what happens if you purchase a property as a revenue property? What if that is your intention? So the question has been asked, what do you want to do with the property? And you've answered, or the landlord has answered, it's going to be used as a rental unit. Well, the tenants that are in place generally then stay in the rental unit. They might give notice and might leave themselves. That's a possibility, certainly. But in general, the tenants just stay in the rental unit, and the purchaser becomes the new landlord for the length of that tenancy. And all the terms agreed to by the previous owner stay in place. And that includes things like the rent, conditions, inspection report, the terms of the tenancy, what services are included. And that can be really difficult. Talking about what services are included is a really important part of the conversation. So if you're going to purchase the property as a revenue property, and there's tenants already in place, that agreement that is in place, all of the things that are included in that agreement is what is going to be in place when you become the landlord, when the new owner becomes the landlord. And when we talk about those included services, we talk about both written and implied services. So in the tenancy agreement, generally you write out what is included in a tenancy agreement. Things like, is heat included? Is hot water included? Is there a dishwasher? But sometimes things are left out, and it's not always on purpose. Sometimes they're left out just because someone forgot about it, or it was added later on and no one thought to add it to the agreement. It was a minor thing. Those services that are included by implication, so simply by the landlord providing it without putting it in the agreement, do form part of that agreement. They form part of that tenancy. And that can be a serious problem if you're not aware of it down the road. So after you become a landlord, because you purchased this tenanted property, you have a tenant who perhaps was expecting that their Wi-Fi, for example, was going to be included. And you as a new purchaser didn't renew the cable, you didn't get your own account, you didn't see any need to. It wasn't in the agreement. The tenant now comes to you and say, hey, I don't have internet, I can't watch my Netflix. This is a problem. Which, fair enough, that's a problem. So you need to be aware of what is written and what is implied in terms of those included services. We can go to the next slide. Actually, we can go to the next slide again. So don't I need to sign a new agreement with the tenants? So it's a good question. Do landlords need to sign a new tenancy agreement when they become the landlords, when they purchase a property? And the answer to that is no. When purchasing a property as a revenue property, as you've already kind of mentioned, in many ways you're inheriting or you're purchasing the agreement that is in place and as it is. You might work with the tenant to try to amend the agreement to change the name, but it's not necessary. It's not a requirement to change the name. And you might have a tenant who wants to sign a new agreement, and that can be done as well. But the end rule on this, the legislation as it is that the tenant does not have to sign a new tenancy agreement with the new purchaser. So it's a really important part to this that needs to be made very aware. Additionally, you need to make sure that you get the whole story. We talked about kind of going into this not knowing everything. Well, paperwork tells a large part of the story. So you need to make sure you need to get all of the paperwork. You move to the next slide. So what should you get from a previous owner? As someone who's brokering this, as a realtor or as a purchaser, what should be requested? Well, the answer to that is everything. You need anything that is relevant to the tenancy. And that might include things like an application for tenancy, tenancy agreement, condition inspection report, the dispute resolution decisions. If the previous owner has gone to dispute resolution with this particular tenant, notices to tenancy that might have been served for previous issues that perhaps were not effective, caution notices, incident reports, rent increases. Really, the whole tenant file should transfer over to the new owner. No exception to that. And this is allowed under the Personal Information Protection Act. That information is allowed to be shared to the new owner. They have a right to that information. So if asked, am I allowed to actually share this information? The answer is yes. That information can be shared to the new purchaser. The new purchaser should expect to get all of this paperwork. This kind of goes back actually to the beginning about learning about the whole story. Now, if you're simply considering purchasing the property, you aren't going to be able to see this type of paperwork. And the landlord shouldn't show you that paperwork because it has personal information, which you shouldn't see until you actually have gone through the process of purchasing the property. But what should be asked is, does the previous owner have this information? We can go to the next slide. So what do I do if the previous owner did not complete all the paperwork? So what if they didn't do some of this? Well, we talked about how purchasing a property is in many ways inheriting or purchasing the agreement that is in place at that time. Well, this is a perfect example of that. Failure on the part of the previous owner to complete any of these documents, such as the condition inspection report, which is a really important part of a piece of documentation, means that you have a tenancy that doesn't have one in place. It's no different as if, it's the same as if you had been the landlord the whole time and you simply did not do one yourself. And you cannot conduct one once you take possession. Now, when I say you cannot conduct one once you take possession, it doesn't mean you can't go in and do an inspection. You can, but the official move-in condition inspection report needs to be done at the beginning of the tenancy when the unit is vacant. And not having all the paperwork can really mean all the difference. It can, not having an agreement can mean you're limited in how you enforce rules, such as no smoking or no pets. If there's no tenancy agreement in place, no written tenancy agreement in place, then the rules that govern this tenancy essentially are the standard rules as provided under the government agreement. So if you look at the residential tenancy agreement provided by the residential tenancy branch, the agreement itself is, I would say, simple is the best way. It's very simplistic. It does not go into great detail. It's not nuanced in any way. And fair enough, the government isn't there to set rules necessarily about how people are going to live, at least in this situation. They're meant really just to make sure that there's a good foundation for understanding what is expected from both parties when it comes to things like rent, the address of the rental unit, and reasonable levels of cleanliness and repair, both from the landlord's and tenant's perspective. When we look at additional rules, such as no smoking or no pets, those are rules that you can have in your agreement, but if you want those rules in place, they need to be in writing. So if you purchase a property, or if you're helping someone purchase a property where there is no tenancy agreement in place, you need to assume that that tenant can have pets in the rental unit, they can smoke in the rental unit, and really do pretty much whatever they want within that rental unit within reasonability. There are certain things they cannot do, certainly, but it's pretty limited in terms of the rules. So it's an important part and really should be discussed before you even get to the purchasing part. It might mean you don't want to purchase that property because it might not be worth it at that time. Additionally, not having a condition inspection report can mean that you are unable to hold the tenant accountable for damage or cleaning. So the condition inspection report is really one of the most vital parts of documentation when it comes to a residential tenancy, specifically when it comes to the state of the rental unit. And not having one essentially means that the landlord, whether it is the original landlord or the person who purchased the property, does not have a right to claim for damage or cleaning that is done to the rent, or that is done or needed to be done to the rental unit. at the end of tenancy. A way of looking at it is you're purchasing all of the successes of that previous landlord. So if they've done everything perfectly correctly and they have great tenants in place, you're purchasing into that situation. You're buying into that situation. But you're also potentially purchasing all of their mistakes, their failures. So if they didn't do a good job at tenant selection and they did not have a tenancy agreement, they did not have a condition inspection report, you're unable to hold the tenant accountable for those things. You aren't able to have those rules in place. There's also things like the security deposit, or in some cases a pet damage deposit, that need to be considered. A security deposit is generally paid at the beginning of the tenancy. It's a half a month's rent. It goes to the landlord at the time. So that needs to be discussed as to how that is going to move over to the new owner, if one was paid. If one was paid and it was documented clearly that it was paid, and the seller doesn't transfer it over to the new owner, the new owner as a landlord is still responsible for that note, for that deposit. So not getting the money from the previous owner doesn't expunge them from that right or that responsibility to deal with the deposit as you normally would at the end of the tenancy, potentially returning the deposit, so that they might be out of pocket for that amount. So again, another important part that needs to be discussed in the process of selling the property and purchasing a property. And it's something that I've seen a few times written into the agreement for that sale. So we can go to the next slide. So this is where we venture off from somewhat of the norm, or what was the norm last year, and what is now the new normal. COVID-19 has certainly brought on new challenges for landlords, property managers, realtors, professionals of all industries, really. And within this industry, there are certain things that need to be done to ensure that realtors, landlords, and tenants are all kept safe. So some of these precautions include not showing the rental unit, for example. Now, I've said that you can show the rental unit, and in many cases, you're going to have to show the rental unit. To sell a property, to be frank, you're going to need to show the rental unit in most cases, unless you have someone who is totally fine buying a property without ever seeing it. But in most cases, that's not going to be the situation. They're going to want to see the property. What we say about not showing the unit is trying to limit it as much as is possible. Make sure that the people who you are showing that rental unit are serious. Doesn't mean they have to necessarily say, yes, I'm buying this unit, but if they're just out to take a look at a new property, but they aren't really necessarily sure they're going to purchase, they don't really know, I wouldn't show that unit in this case. I'd say you need to really make sure that they are looking for a very specific property and this meets that criteria. Also recommend at this time, while it is technically allowed, to not serve things like, not do things like host an open house. That's certainly a thing that can be done in normal situations, and technically legally it can be done right now, but it's not recommended. It's very difficult to keep everyone safe in that situation. We then look at, well, what do you do if you do in fact need to show the rental unit? You have no choice, you need to show it to a potential purchaser. Well, normal social distancing practices should be maintained throughout that process. So making sure that you're keeping at least 2 meters away, 6 feet away from each other. That includes you and the tenant and you and the potential purchaser. You can ask the tenant to leave the rental unit if that would help, and hopefully they will. They don't have to leave. They have the right to be there if they want to. And that's when we go back to the kind of getting their buy-in, perhaps giving them a gift card to the Starbucks down the road to say, hey, why don't you go grab a coffee? It's obviously in this situation especially advantageous because it means there's less people in the unit. It's easier to socially distance. You also want to make sure you're not, part of social distancing is also doing things like not shaking each other's hands. Not touching services as well. Ask the potential purchaser to not touch things, especially the tenant's belongings. As a realtor, as a landlord, going in there, bring some cleaner with you, wipe down surfaces that do get touched, like doorknobs and such. Wear a mask. Have masks for the potential purchasers as well. Potential idea there would be to have branded masks with the firm name on it. But having masks available to everyone is a really, really good process in ensuring that everyone will have a mask when showing the rental unit. You can find information about these types of precautions on our website at landlordbc.ca/COVID-19. We have quite a bit of other information on there as well. So that ends our slides presentation. So I'll invite Darcy, and I think Kim is coming back on as well.
Thank you so much, Hunter. And thanks again, Kimberly. You both gave us some great information there. We're now going to open it up to some questions for the next 20 minutes or so. For all of you participants, all 83 of you I see. You can type your questions into the Q&A. Some of you have already done that. We have a few questions in the queue already. So if you want an answer from a specific guest, either Hunter or Kimberly, just put the name at the beginning of your question. Otherwise, we'll just leave it up to Hunter and Kimberly to answer as they choose. You can take turns or however you'd like to do that, guys. First question is from Marty Pospisil. I cannot find the caution notice on the RTD site. Is there a standard form online for this? And I know, Hunter, that was in your presentation, so maybe you want to take that one.
Certainly. So when we say caution notice, it kind of means two things. There is, in fact, a caution notice that we provide to our members. It is not a standard form as per the Residential Tenancy Act. It does comply with the Residential Tenancy Act. You won't find a caution notice on the Residential Tenancy branch website. What you will find is in the Residential Tenancy Act, it says that to give notice to tenancy for something like this, there needs to be written notice. You need to warn the tenant in advance. So the Act says this, but they don't provide a form for it. So we provided a form for our members specifically, and it's found in the members only section of the Landlord BC website.
Great, thanks, Hunter. Great answer. Next question is from Rob Allegrini. Who pays the 12-month penalty, the buyer or the seller? I guess this is in relation to purchase of a property where the tenant is given notice that the new owner intends to live there.
Certainly, and I'll take this one as well, and it is the purchaser. So just to be very clear, if you have a situation where you're selling a tenanted property and the new owner wants to move into the unit, or they say they want to move into the unit, their name gets put on that notice to tenancy that is served to the tenant. So the new purchaser's name is made available to the tenant, and should it be found out that this was served in bad faith, then the penalty is supposed to be paid by the new purchaser, the person who owns it at that time. So again, that can be a bit of obviously it's a steep penalty. Everyone needs to be very aware of it, and the seller should be aware of this as well, because if something happens and that new purchaser can't be found, the tenant might come after the seller as well. And I can't say 100% what would end up happening in that case if they did do that, and the tenant showed that they couldn't find the new purchaser. So, but in general, it's the purchaser that would pay that. So
the purchaser is responsible for that notice. Mm-hmm. And actually, I think the purchaser has to sign notice saying that they intend to, in good faith, use the property themselves, right? That is correct, yeah. Okay, perfect. Next question is from Peggy Louise. It just says, didn't discuss the last slide, ending a tenancy when there's a fixed term. I think the question is, what do we do if there's a fixed term? Can we end a tenancy, and how do we do that?
Yeah, so we kind of covered this by saying that if you have a fixed term tenancy in place, you cannot end that tenancy prior to the end of that fixed term. So a fixed term tenancy says, this is going to be a 1-year tenancy and it will end on such and such a date, 12 months from now, whatever the date is. That notice to end tenancy cannot be effective. The 2-month notice to end tenancy cannot be effective before the end of that fixed term. Now, in cases like this, where you do have a fixed term tenancy, this is a case where you might want to work with the tenant at coming to a mutual agreement to end tenancy. And that's perfectly fine. Mutual agreement to end tenancies can be used. They're a very effective tool, certainly, but it requires that both parties are in agreement to ending the tenancy. And that's something that is not always possible. You might have a tenant who simply doesn't want to leave. They don't want to agree to end the tenancy. Or they might only agree if they get some type of compensation. And certainly if serving a 2-month notice, they would get at least 1 month compensation. So when doing a mutual agreement to end tenancy for this reason, it would stand to reason that you would offer at least 1 month compensation, potentially more. And sometimes that's worth it, certainly.
Yeah, in many cases it probably would be. Thank you again, Hunter. Kimberly, how do you think Hunter's doing here?
Oh, Hunter does a great job. There's no question when it comes to questions about the Residential Tenancy Act and the legislation. Hunter and his whole team are really just your go-to.
We pay her to say that.
That's not true.
That was a completely unprompted question, Hunter. We didn't rehearse that at all.
Not at all.
Okay, the next question is from Mary Sutherland. This one's got a little more detail to it. I have listed a property which will go on the market July 15th. They're having visitors stay from July 17th to July 25th. It's a 1-bedroom apartment. When the landlord informed them that it was listed, they did not tell her about the house guests that are from Calgary. The tenants have just returned from Calgary. I checked with BC COVID-19 and was told that they did not have to self-isolate. Is this true? And any suggestions? I think this is kind of a double-barrel question. Any suggestions on how to deal with the potential COVID issue with a visitor from out of province? And how does them having house guests impact our ability to show the property, if at all?
Yeah, well, thank you for that question. That's a complicated one. It's one that is certainly an evolving situation when it comes to how we approach COVID-19 and the situations that come from that. In general, from my understanding, and I am not a public health expert by any means, but my understanding is the same that you had when you found that information, is that someone who is traveling from one province to another does not have a requirement to self-isolate. Obviously, we'd probably like that in some cases, but it's not a requirement for them to self-isolate. From my understanding, I have not seen any rules about that whatsoever. So, as that is the case, you can show the unit. You would give a normal notice of entry, as we've discussed in our presentation. Now, obviously, in a situation like this, you might say, you know what, okay, maybe I'll hold off if I can till the 25th, till that person is gone. Of course, that might mean the person who's living in the unit is potentially causing some problems if they end up testing positive themselves. So you do have to use your judgment in that case. And I would say that you might want to exercise some additional caution when serving that notice, but ultimately, as per the law, you are allowed to serve that notice and enter the property. You're allowed to give a notice of entry and enter the property. Again, like I said, you might choose to forego that. And in normal situations, regardless of COVID-19, if a tenant comes to you and says, hey, I have house guests during this time frame, well, you might choose at that point again to simply not show the unit during that time. Anyway, I know it might certainly hinder the selling the property, but having house guests in the unit might also hinder selling the property. You don't know, maybe they have the couch pulled out and there's a suitcase everywhere, and now you have another person who's in the property. They all have to go out. It's quite an inconvenience, certainly. So there's quite a few reasons as to why you might choose to hold off on that case in that situation in general, but if you absolutely have to, you can still go in.
Okay, thank you. So the notice for entering the property applies to house guests as well as it does to...
yeah, it applies to the property in general.
Yeah, okay. Okay, so this one is about tenant troubles. Tenants who are constantly disturbing a neighbor, does this warrant a caution notice? And what if there's no tenancy agreement?
So 2 questions.
I think though, what if there's no tenancy agreement? It could be a separate question. So,
and we're going to address those separately because they are 2 completely separate things. So when we talk about tenants who are constantly disturbing a neighbor, does this warrant a caution notice? The answer to that is yes, it likely does. Now we have to look at some really key factors in terms of giving a caution notice. We talked earlier in the presentation that serving a 1-month notice to end tenancy is a significant step. You're ending someone's tenancy, and the step prior to that is the caution notice. So really, when it comes to serving a caution notice, you need to be sure that you are comfortable moving to the next step, which is serving that notice to end tenancy. It's not a small situation by any means. It's very significant. It needs to be considered heavily. We have to look at, okay, this person is disrupting the other tenants. Well, how are they disrupting them? How much are they disrupting them? When are they disrupting? How often are they disrupting? Would a reasonable person be disrupted by this? And by example of this, is it that they're annoyed that, at 9 in the morning every day they make a smoothie, which I can attest when neighbors do that, it's kind of annoying, but it's not unreasonable. It's 9 in the morning. In fact, that's kind of late to be making a smoothie in the day. It's also late for me to be at home, but nonetheless, it's not unreasonable. The person's being annoyed. So you have to interrogate the situation to make sure that it is significant enough. But if it is, if what they're doing is, playing loud music at 2 in the morning every day, well, that's significant. If they're making that smoothie at 3 a.m., that's significant disruption. So certainly you could issue a caution notice, and that we recommend having a conversation with them first to try to avoid going down that path. But if you can't, then the caution notice. And this is regardless of whether or not there's a tenancy agreement.
Okay. So
tenancy agreements, they set some rules about, you can set some rules about, quiet hours and things like that. But if it's significant disruption, it doesn't matter whether there's a tenancy agreement in place or not. That's standard to the Residential Tenancy Act itself.
Okay, so do you want to go to the next part of this question?
Yeah.
What if there is no tenancy agreement? What does a new owner do, or what is somebody that may have inherited that situation or is in that situation where there's a tenant in place, there is no written agreement? How do you deal with that?
Carefully. So, really, what it comes down to is if you don't have a tenancy agreement in place, whether it's just a tenancy that you have right now, it doesn't matter whether it's for purchase or sale or not, it doesn't matter. If there's no tenancy agreement that is in place in writing, it doesn't mean there's no tenancy agreement in place. It just means there's nothing in writing. So you would, in that situation, need to refer back to the government agreement. If you look at the Residential Tenancy Branch website, you'll find a tenancy agreement on their website. That agreement is in place for every single residential tenancy in this province, regardless. It does not matter if you've signed something or not. It doesn't matter if you signed something else or not. The rules of that agreement apply to every single tenancy. If you look at the Landlord BC agreement that we provide to our members, it has all of those terms that are provided in that government agreement. So all of the standard terms as provided by the Residential Tenancy Act are in place no matter what. But as we mentioned before, those standard terms are really basic. They do not go into great detail about the rules of that tenancy. They don't say things like no pets, no smoking. It says things like rent is this much, this is the address of the rental unit, these are the basic things included, reasonable cleanliness must be kept, reasonable repair must be kept, landlords have to give notice of entry before entering. Those are the kind of basic things that are covered by it. So whether, again, purchasing or if it's a tenancy that's just occurring naturally, it doesn't matter. It's that agreement is always in place.
So I'm going to ask a question related to this that I've seen pop up in this chat, but can you, as a new owner of a tenant-occupied property, can you require that tenant to sign an agreement with you?
The answer is you can ask. So asking a tenant to sign an agreement is fine, though there are some things that should be considered before doing that, and some potential problems with that. In some cases, it's worth it. If an agreement is already in place, then the agreement is in place. Even if it's not, again, even if it's not in writing, it's in place. So the tenant does not have to sign anything with a new purchaser. If there is no tenancy agreement in writing already, then I would definitely recommend the purchaser ask the tenant to sign an agreement with them. But again, the tenant doesn't have to sign it. It's certainly, but it's in their best interest. If an agreement is already in place, however, if a tenancy agreement in writing is already in place, then I would not recommend signing a new agreement, even if it makes things a little cleaner because it's got the new person's name on it. And the reason for that is it just creates some confusion around the paperwork in general. It doesn't match up with things like the moving inspection, which is really important to be done at the beginning of the tenancy, not when someone purchases a property.
Right. Okay, we'll go to the next question. Thank you, Hunter. Next question is from Max Shamarati. Does a landlord need to give notice, or I guess two parts, notice and 1 month free rent at the end of a fixed term rental agreement?
Yeah, so does a landlord need to give 1 month free rent after a fixed term rental, even if the fixed term agreement, even if a fixed term agreement is signed? And the answer to that is yes. When serving a 2 month notice to end tenancy, the tenant is always entitled to 1 month compensation, regardless of the type of tenancy, whether it's a fixed term or month to month. Now, that's if serving a 2 month notice. To kind of confuse the situation, or perhaps hopefully better explain the situation, there are sometimes situations where you will have a fixed term tenancy where it says the tenancy ends in vacant possession. And this is where the confusion can come in. The first thing to know about fixed term tenancies that state that the tenant must vacate at the end of the fixed term, they can only be used in situations where the owner intends, or their close family member intends, to move into the rental unit at the end of the fixed term. So that wouldn't be something that's used in situations where you have a purchaser. So that wouldn't apply in that case. But in those situations, if you did have a fixed term where we're not talking about sale of the property or anything like that, then no compensation is given. But that's a very, very narrow situation, and it has nothing to do with the selling or purchasing of a property. And that's where sometimes that confusion can come in. So the real thing to know is 2 month notice always gets 1 month compensation.
So even if there is a fixed term and you're giving the tenant notice that you're not going to extend that fixed term because the owner is going to move in, or the new owner is going to move in, they still get the 1 month compensation.
So you're not, so that's where the confusion comes into play. So if we look at that situation that you just said, you have a new owner, you have a fixed term that said vacant possession. Well, you can only do the vacant possession. You can only sign that if it's because you as the owner at the time of signing it intend to move in. So there would be really no way of using a fixed term tenancy with a vacant possession for the process of selling a property. It is a different reason. So the 2-month notice would have to be used in that case.
Okay. And the effective date of the notice cannot be before the end of the fixed term.
Exactly.
Perfect. Thank you. Next question is from Roberto Testini. What if the tenant's lack of cleanliness and damage to the unit cause a loss of value to the unit? What recourse is there for the landlord?
So that's a really significant thing, and certainly one that likely should have been addressed prior to getting to the point of selling the property, to be perfectly honest. This is one of those situations where if you have a tenant who has, and we often see this, where if we have a tenant who has left the unit quite messy, and it's potentially damaging the property and reducing the value of the property, that needs to be addressed as that is occurring. We often do see that it comes up really only when you go to sell the property, because that's when the owner decides to do an inspection. But this is an example of why those inspections need to be done kind of regularly. We recommend doing inspection about twice a year. So what is the recourse that a landlord has? Well, certainly the caution notice and a notice to end tenancy are potential recourse in a situation like this, regardless of whether the unit is for sale or not. Regarding the potential monetary loss, that is something that the Act doesn't prohibit. You could go after that monetary loss. You'd have to prove it, and it's something that I can say has not gone through the residential tenancy branch, at least often. So we don't really have a lot to really compare that to, but the Act doesn't prohibit someone making a claim that, you know, this should have gone for $5,000 more because of this, what the tenant has done. I want that $10,000 from, or that $5,000 from that tenant. It's difficult to prove. It's really difficult to prove that. I don't know that in any situation you really be all that successful with it. And like I said, we don't have a lot of cases at the residential tenancy branch to really look at to see how those types of situations would be actually decided. It's simply just not prohibited under the Act.
Okay, if we back that up a little bit, the tenant is responsible, though, for damage to the property, provided that there is a move-in inspection and a move-out inspection.
So that part itself, they'd be responsible for.
So the damage to the property, if it's in excess of the deposit that was taken, they're still responsible for it. That's correct? That
is correct.
Okay. Okay, so I know you talked about this next question a little bit. It's from Jessica Guan. And her question is, what kind of agreement letters do I need to make sure a new owner can move in order to serve 2-month notice to end tenancy? So the process for a buyer to be enabled to have that notice served on their behalf.
Yeah, so certainly there should be a statement that is signed by the potential purchaser or from the purchaser, stating that they do in fact intend to move in to the rental unit. I know that most realtors, I've seen a few that realtors have provided, and I believe there's also one on the residential tenancy branch website as well. Though I don't know that it's actually in the forms section. Sometimes they have their forms within the site itself. But certainly that's something that the very least needs to be in writing, where it's very clear about what the purchaser intends on doing. So again, just a statement really clear to the point that they intend on doing this. Okay,
perfect. Next question is from Mark George. And just before I go to that question, Hunter and Kimberly, we're about 11:20 now. How are you guys for time? I know we initially said that we'd be probably wrapping up around 11:20 to 11:25. So I just want to make sure you guys are okay.
Yep.
So okay for a couple more questions? Perfect. Okay, the question from Mark is, I've had a situation when selling a tenant occupied property where the buyers are going to keep the tenant. The buyers have requested to meet the tenants before the completion date, before they become the official landlord. Is there any obligation for the seller of the property to allow the purchaser to meet with the tenant? And is there any benefit to the seller to refuse that?
Good question. So, I mean, I would say that in a situation like this, you know, letting people meet can be a great way of ensuring that the relationship that's going to occur after that is going to be positive. Obviously, you'd want to really talk with your tenant in advance. You really want to make sure that everyone's on the same page before you get to the point of meeting, making sure that that meeting is going to be as positive as possible. I would say that there clearly could be some possible issues with that if the tenant doesn't really know what to say and isn't really on board with the process. So certainly, I would say that if you're going to do this, which I can see the benefit in doing it, certainly, just the benefit of making sure that that relationship is as positive as possible. Yeah, I'd say that just make sure you have that conversation in advance. You're not coaching them to say this exact thing by any means, just making sure that they're comfortable with what this conversation is going to be. And same with the other side as well, having that conversation in advance, saying, okay, well, you know, I'm totally fine with doing this. Could you perhaps just give me a bit of insight as to what you're going to be asking this person?
Right.
And in terms of benefit for the seller to refuse, well, I mean, obviously there could be benefit if you know that tenant is clearly going to basically tell lies or maybe the truth in that case about situations that might be or might not be occurring in that property. So it's certainly, you know, there's pros and cons to this, but it's going to be very situation dependent.
And the tenant really has no obligation to speak to
the
new owner until they actually become the owner, right?
And even then, the truth of the matter is there's no obligation for tenants to speak to landlords in general. They have to pay the rent. They have to, you know, they don't have to really do much in the way of communication. So.
Okay. Interesting. Next question is from Chloe Kopman. Again, it's a question for Hunter. Hunter, you're getting all the questions. Kimberly, you're just sitting there smiling and looking good.
Hey, I'm learning things too.
If a new landlord does not comply with the rules and rents the property out to someone other than a family member, and the 12-month rent penalty comes into play, who gets the 12 months rent? The old tenant, or does it just go to the tenancy board?
It goes to the old tenant. So, and this is actually an important thing to be aware of in the process. For the penalty to come into play, the tenant who moved out needs to actually file through the residential tenancy branch to claim for that. So it is something that can be done, but it is something that has to be done through that process. It's the standard dispute resolution process.
So the tenant that was given the notice gets the money.
That's correct. Yeah. So it is done. It's specifically it is a benefit to them, which can kind of. I mean, clearly that can certainly create some motivation for the tenant to make that application. Otherwise, it'd really be, you know, the residential tenancy branch isn't in the business of going in and investigating things independently. They have to be alerted of something. And that's something that, you know, like I said, it does need to be, it needs to be initiated by the tenant, but obviously they have a very, very significant motivation to do it.
Right.
One thing to add to that, Hunter, and this has come up, we've had landlords contact us about this, and they've gone about ending the tenancy to move immediate family in and they had every intention of doing that. But somewhere after they've issued that notice, their plans have changed and they decided, oh, actually my daughter's not going to move in there now. So they relist the unit. And unfortunately, that violates the Residential Tenancy Act. So those landlords were on the hook for that 12-month compensation. And often the way tenants find out that this is happening is because they're looking for housing and they see their old unit listed for rent. So even if you're looking to end that tenancy to move immediate family in with the best of intentions, you need to be prepared to follow through on that. It's not something that you can just do thinking, okay, this might work out, it might not, because you would be on the hook for violating the Residential Tenancy Act, even if that wasn't your intention from the onset and plans change. So you just need to be aware that ending a tenancy is a very serious process, and you are expected to follow it through according to legislation.
Thanks.
And just a further point to that too, there's a lot to this actually. I mean, the penalty is significant. As we said, 12 months rent is not a small amount by any means whatsoever. So you really need to be 100% sure that what you are doing is what you in fact want to do, that you do want to move in. So when talking to a potential purchaser, you need to ask that question like 20 times before you actually get to that process of serving, because they don't want to, you don't want them to be unhappy that they have to pay 12 months rent. But, you know, obviously situations do sometimes arise where they don't follow through with it. And in that situation, if they do not follow through with the notice, you could go with, you could make an argument that it wasn't served in bad faith, but that it's that it simply was something that happened outside of their control, and that you don't have to pay that. And that an arbitrator does have to take that in consideration. But to be able to prove that, it's really, really difficult. And so you need to go into that situation with the basically understanding that you'll likely have to pay for this pretty much no matter what, if you don't move in. Again, it's not 100% guarantee. It doesn't mean that it will happen 100%, but it certainly can. And it should be it should be the expectation that that is what is going to happen.
Okay, perfect. Thank you. We're just going to do a couple more questions and then wrap up. So all of you that are waiting to get onto something else, we've got a couple minutes here. If a buyer's late for their scheduled and approved showing to access a rental unit, how long does the tenant have before they can just say no? Like if it's scheduled between 1 and 1:30 and the buyer or buyer's agent is past 1:30, can they just say no, that's outside of our agreed time?
Yeah, so that's a really good question. One that doesn't have an answer, to be perfectly honest. I generally always try to have some type of answer for these types of things. But this is not one that has a set answer. It doesn't say in the Residential Tenancy Act whether or not this, or how long the tenant has, or how long a landlord has. We generally say, you know, if it's more than 15, 20 minutes, then yeah, you're going to want to reschedule. That person shouldn't, person was quite late. We also recommend that you do as much as you can to not get into that situation at all. And you do that by really communicating with the tenant up front, making sure that they're aware that, you know, this is a window of opportunity. So we're going to be coming in between 10 a.m. and 11. Now, when you give a notice of entry, technically it has to be a set time. But if you're working with the tenant and you have that good rapport with them, that's where you can kind of set that up, that it's going to be between this time. So
okay, perfect.
Again, it's not one that has a set answer. It's simply it doesn't say it in the act. I mean, I think that it could be argued both ways. If it went to dispute resolution, it really comes down to what's reasonable. I mean, if the person is 5 minutes late, well, it's not that unreasonable. 20 minutes late, well, that's starting to become a little unreasonable if the tenant is, you know, wanting to get on with their day.
Right. So, I mean, good practice may be to allow a little bit more range there, that you're going to have
And
people accessing the property during this time period.
exactly.
Okay. We're going to wrap up with kind of two questions, but I'll put them into one. Just like you wrapped up your presentation on COVID, we're going to wrap this one up with a question about COVID. Should we be asking tenants to sign a COVID waiver to allow us to show the property and kind of protect all parties, the landlord, the listing agent, the buyer's agent, the potential buyers? And part two of the question is, can the tenant refuse showings because of fear of infection with COVID?
Yeah, so that is a really good question. Those are two really good questions. The first thing about waivers, yeah, we actually have one on our COVID-19 website. It's on there right now. And so under showing tenanted properties, we have that in there about how to show those properties safely, and there is a waiver on that. So that's something that's available. We're currently making it available to everyone. And then so yeah, or if you come up with your own waiver, that's perfectly fine. Then we look at, so the other part to the question is can a tenant refuse? The answer is currently no. If proper notice of entry is served, then the answer to that is no. The tenant cannot refuse when proper notice of entry is served. If we were asked this question a few weeks ago, the answer would be yes. In fact, a few weeks ago, under a ministerial order, landlords simply couldn't enter a property at all unless they had the consent of a tenant. That was a specific measure put in place because of COVID-19. But that measure has since been repealed. And as of now, proper notice is served. That's really all that's needed to be done.
Thank you. And that's our last question. So thanks everyone who submitted questions. I'm sorry we didn't get to them all. Obviously we're limited on time. Those were some fantastic questions, and Hunter and Kimberly, some great answers. So thanks again. As we wrap up the event, I'd like to once again thank our title sponsor, By Design Construction, for their support in sponsoring the event. Thank you all for joining us today. 80 some participants, so it's great to have you join us. And special thanks again to Hunter and Kimberly. You guys did a great job, and it's great to have you join us.
Perfect. Thank you very much for having us.
Thank you.
Thank you. Everybody enjoy your day.
Thanks.